I'm
disappointed.
No, not at all. What should I do? It's what we expect to have. But I want our people to be very calm. I want Biafra land to be calm and peaceful. Calm and very, very peaceful. We are fighting to defend our people, not to kill them.
Yes.
We are fighting to defend them. That's why I'm here. I will continue to do so until we get victory.
People are waiting for us.
Yes.
So, and it's compelling also, needful that you advise and also put through as to what happened in court today. We are going to speak the English language for the benefit of those who are not understanding the Igbo language. So, because last time some people were actually asking questions, they are not understanding what you are speaking in Igbo language. So, of course, you know, this project cut across the Afghan nation and other places.
Yes.
So today the matter came up for ruling on application to vacate the order, revoking bail granted Nnamdi Kanu sometime in 2017. Then I know opposition to that revocation of his bail in 2017, a bench warrant was issued. So, however, we promptly filed an application to set aside in 2019. We promptly filed an application to set aside that order revoking his bail in the same 2019. And that application was filed on the first day of May, the first day of April 2019. Served on the prosecution, and they responded, and we also filed our reply on point of law. From that 2019, 1st of April, it was filed, stretched to 2022. We have repeatedly brought that to the attention of my Lord, the court, that we have this application. Because this application sought in substance to explain to the court what led to the disappearance of Nnamdi Kanu, what happened in his place on 14th of September 2017, how the military invaded his premises, how 28 persons were murdered there in cold blood, how he narrowly escaped being killed. And more so is the fact that these are facts clearly verified on oath by Nnamdi Kanu when he was in Israel. So he stated, because it's evidence of an eyewitness, he was there, he's the victim. So he stated clearly what transpired in his house, how he managed to escape. So, and this evidence and evidence is very compelling for the court to understand also. I give it a serious weight. But unfortunately today, the court delivered a ruling, and we understand that the court said that there was no application that was filed before her except this year. That we waited till 2022 to file application to explain his whereabouts. That we also, that has been addressed, because I understand that may be it's an error which is seriously wrong indeed, because the application was filed on 1st of April 2019. So it was filed promptly. And that application is very compelling. If it was given meritorious consideration, I believe that the ruling of today would have been different. Despite the fact that court said we can still come back to him, and also with further information and facts regarding to what happened in his house on September 14, 2017. However, we have gone on appeal. We are now before the Court of Appeal challenging the charge, challenging the returning of the 7-count charge out of 15 by the court. So, and we followed it up to ensure the appeal was entered in good time, and also have an application, a motion to hear the appeal speedily. Of course, under the Court of Appeal fact-track direction, the appeal of first session is such which fall within classification of the appeal can be had speedily. And we also followed it up with an application for accelerated hearing, which has been, which court has magnanimously given us 11th of October for hearing. It hasn't been happened. It hasn't happened before. So, and we believe that from the look of things and from the position of things as it stands in this court today, that we'll get justice in the Court of Appeal. So obviously, because 3 heads better than 1. So we are trying on our appeal, including the one of the one of the final part of the ruling delivered today. We are going to also appeal against it too. So, however, and based on the persuasive argument of Nestle, who is now leading us, she was looking at SAN, the court has still proceeding to the court on the matter. So the court will no longer, in general, should entertain this case again, pending the termination of the matters, or the appeal will file before the Court of Appeal. So we have other serious applications or serious suits before the court, which will, one way or the other, determine the entire proceedings. And we are of the view that when this appeal is heard, appeal also challenging the returning of 7-count charge before this court, and when it's heard and determined, most most positively, I can assure you that will be the end of the case. And now they can walk out. So, as you have heard him in court, he continued to advocate for peaceful conduct and civility. And he continued to advocate. In fact, he was forced to say it out today. Because we know that you people most times are being provocated, are being tried to go into certain activities that may probably lead to arrest. But we have to avoid it. Because we know what you are passing through today. So our prayers for you is that you go back to your various destinations safely. And while you are traveling, you have to be very careful. Because we have a lot of enemies now who are all over the places looking for who to devour. But it will not be your portion. And we are assuring you that we're not resting our oaths. All the lawyers in this case, we're not resting to show that Nnamdi is out. And he will be out soon. And it will be total. Thank you so much for coming. Bless you exceedingly and also grant you safe journey back to your various destinations. And remain blessed. Thank you so much. Thank you so much.
You say what? Help us and tell Nnamdi the Nigerian government, if they did not release Nnamdi, this election will not, this Nigeria will not contain all of us.
I'll convert to you.
Where you go? Yes, I'm full. All right. Great.
Prince is okay.
Prince.
Oh, yeah.
Not even because I know the victory was Nnamdi Kanu has done nothing wrong. But he's fighting for a common that has to do with freedom. Justice. That's what. So nobody should underestimate us. Biafrans. Well, what happened? There was a whole lot of arguments in the report. You and I know that the Southern Judge, of course, denied the application made for this matter, and also the question of jurisdiction. She had a so the defense team already had agreed to proceed to appeal court, and that is what is after taking place today. So in the next couple of weeks to come, you will hear about other people. So definitely, I understand what will come out. And that's it. But we know here that we won't get justice here. And in this court, there will be justice. But at the appeal court, there will be justice. And that's what it is.
So you think Nigeria is taking the case to?
Yeah, of course, yeah, that's where we are. We've done that already. Yes, thank you so much.
So what do you expect at the end of it?
Of course, the Muslim must be free. Biafrans must be free.
God bless you.
We are still live at Federal High Court, Abuja, to get more updates on what happened today in the court. So we are still waiting for our barrister to address the press.
That she let the prospect for a new application for bail open. Obuna Defense Choi brings such application forward that she's going to reconsider her decision. That's number one. Number two, based on the matter that is pending before the Court of Appeal, namely the challenge to the jurisdiction of the High Court to put Mazi to trial based on extraordinary rendition. That matter is pending on appeal before the Court of Appeal. The judge granted stay of further proceedings of the criminal case, pending determination of that question of jurisdiction before the Court of Appeal. So that is what happened in court today, and then the matter was adjourned to November 13th for mention. Court of Appeal, but I can assure you that between now and that 14th November, a lot of things will happen. Both in Abuja here, presumably by my colleagues, but I'm so sure of what I'm going to do. I'm going to move mountains to Roma. Yes.
We just finished interviewing one of our barristers, the special counsel of the indigenous